Live from America's heartland, this is the Daily Truth Report with your host, Noah Christopher.
Welcome back to the Daily Truth Report. I'm your host, Noah, and we have a real pleasure today, a first-time guest on the show, but I know many of you know him already just by seeing him on the screen. Joining us today is Lloyd Brunson. And Lloyd, it is a true pleasure to have you on the show. I didn't know that we'd ever get a chance to chat, but I've been excited about it ever since we booked this a couple days ago. So welcome, and it's such a pleasure to have you here.
That's great to be here. Thanks, Noah, for having me.
Yeah, you bet. We've been covering what you were doing with your brothers as well since we first heard about you back in the fall. And when someone first told me about your case, it almost sounded too good to be true. And so they sent me the email, and I thought, well, I'll go look this up. And then sure enough, I found you on the Supreme Court docket, and I thought, well, wait a second, this thing's real. And of course, from there, we've had a lot of things happen, but that's kind of where I'd like to start. I know a lot of people know you and are probably just as big of a fan as I am of what you're doing. But before we even talk about the cases, you and your brothers have really taken it upon yourselves to do what the attorneys and the trained professionals seem to have given up on or neglected their duties. So I guess my first question is, now, do you have any formal legal training, or are you just all self-taught with this stuff?
No, it's all self-taught. Mostly one of the three brothers has experienced litigating in state and federal court, and he's been able to have 2 petitions for writ of certiorari. That's an appeal to the Supreme Court. He successfully had docketed twice, 2 different ones. And so that's a pretty complex thing to be able to do, but he's self-taught. So
incredible. Wow. Well, and I've seen a lot of your videos where you talk about you pull open the Constitution and you start reading it, and it's amazing what's in there, isn't it?
It is amazing, yes. I've published some books on it, and at 7discoveries.com, you can find the most revolutionary pocket-sized book that has the Constitution, Declaration of Independence, the Bill of Rights in it. And it's I'll just say real briefly, one of the reasons it's the most incredible, and that is there is not a Constitution book in existence that shows that the first 10 amendments amended a darn thing in the 7 articles, which is wrong, because it did. And so as we look at the document carefully and connect the dots, we will see, and if you go to 7discoveries.com and order my Pocket Constitution, I think is what it's called, plus much more, because it is much more than a Pocket Constitution, it'll show you those power clauses. And then you'll begin to realize why they've been ignored, because they're pretty powerful clauses that push back against what's happening today.
Yeah,
so
that's
I've
great.
been doing it for about 14 years. And so my brother that had experience suing, we got together and decided to launch a lawsuit, against the people in Congress that push back against a simple investigation. So the lawsuit, we're suing Joe Biden, Kamala Harris, and 386 others, Mike Pence, not because of the outcome of the election, and not because of was there enough fraud to make a difference. That has really little to do with it. We're suing because there should be an investigation, and there wasn't, and they pushed back against a simple 10-day investigation to put it to rest as to was there enough or not, for sure. And if there was any infiltration or invasion, through our election system, then an investigation should find that out. It's like you see a little crime. I mean, how many criminals have been locked up, murderers that were caught because of a tail light was out, right? And they stop the car and realize, hey, this person's wanted, and they just saved some lives. So you can't look at the election and say it's just a tail light. You can't do that, and that's what they did, and that's why we filed lawsuits. We've had about 4 lawsuits having to do with them breaking their oath of office to defend the Constitution from all enemies, domestic and foreign, which includes investigating possible deeper crimes that are taking place with the evidence that was shown to them that they refused to allow an investigation into for 10 days.
Yeah, wow. Well, we're recording this on May 24th, 2023. And like I said, Lloyd, we've been covering what you're doing since last year. And I wonder if you could maybe take us back just a little bit. The beauty of what you're doing is how simple it is. And I mean that in the most respectful way. Like you said, you don't have to go through and prove a bunch of fraud. You have to prove one thing, that they didn't do the investigation, and that compromises national security. So it's incredible how beautifully simplistic it is. And I love that. But I wonder if you could back up just a bit. We're on the second case now, as I understand it. The first one we covered, we were very excited about. It did ultimately get denied, or they refused to hear it. I don't know the exact term,
that's correct.
Would you tell us what a quick summary of that first case, and then what's different about the second case, and what comes next? Give us a brief history there.
Yeah, well, that case that went to the Supreme Court first was actually the second case, because my case, which is really the first case, got stuck in federal court. And so we thought, hey, let's launch another one. We'll have different judges. We'll see if it gets to the Supreme Court quicker. And that was our goal, is to get it to the Supreme Court, to have the final say. And so my brother Roland became the plaintiff on that, and that was on a fast track. We learned a lot from my case, and while mine's being stuck, his went forward. And then it was denied a hearing. And so even though it was denied a hearing, it's still on the shelf. They could pull it out. But what's fantastic about this is it laid the groundwork, and over 70,000 people supported with letters that first petition. And that's a permanent record. And believe me, the justices are aware of that. Now, this one is sort of like on a fast track now because of the experience with the other one. For example, the United States Solicitor General came on board immediately on my case. It was just filed on the 24th. And Rollins' case, it took until the deadline for her to come on, the Solicitor General to come on. So to give a little background of my case, because that's really the one that we're talking about, and that there's a deadline right now for the Solicitor General to respond to tonight at midnight, see if she's going to oppose it or not. If she doesn't oppose it, then it gets set a date for conference, and whether she opposes it or not, it goes to conference. So to give a little background, maybe I can just say on March 31st, 2021, the Federal Court of Utah ordered the U.S. Marshal Service in Washington, D.C. to start serving my summons and complaint. And according to the docket on March 31st, 2021, 84 defendants were served on Capitol Hill. Now, why U.S. Marshals? Why are they serving my summons and complaint? Well, they had locked themselves down. Congress had locked themselves down, not allowing any kind of people going in and doing what we needed done, service of a complaint. So we couldn't hire a process server. We couldn't hire a deputy sheriff, anyone like that. So the court actually ordered the U.S. Marshal Service to do that. So the U.S. Marshal Service, according to the docket, successfully served my summons and complaint on March 31st, 2021, Nancy Pelosi, Maxine Waters, Adam Schiff, and about 81 others. Now, the next day, the court canceled that, recalled it, said that my complaint was deficient, and then unfiled my case. Well, courts can't do that. That's illegal. The judge cannot interfere with a case before the defendants respond. And so we knew they had done some wrong there. So we decided to complain to the 10th Circuit Court of Appeals with what is called a writ of mandamus. And so the 10th Circuit Court of Appeals responded with, oh, they haven't canceled your case. Oh, they haven't done this and that. They're busy, and it's going to take some time. And it's like, you didn't even read what we sent you. We told you that they canceled it. They canceled my service. You can't do that. It's like they weren't even paying attention to the pleadings. So because of that, we took action against both courts, the Federal Court of Utah and the 10th Circuit Court of Appeals. We took in a lawsuit, we took them to the state court. Okay, so the state court was taking time making a decision because the U.S. attorneys were filing a motion to dismiss, and we were fighting that back and forth. Finally, it was time for the judge to make a decision, and he wouldn't make a decision. So meanwhile, my brother's case is moving forward, and it's interesting because they're admitting to wrongdoing in my brother's case. They're referencing my case. So we take that information and we file what is called a full summary judgment motion. And that is, if you have enough evidence, you can appeal to the judge and say, hey, here's the evidence. They're basically admitting wrong here. We don't need to go to trial. We don't need to have, you can adjudicate this. You can judge this without going to trial because it's so obviously wrong what they did, and you can adjudicate it. And so he kind of held off on that and didn't do anything. And finally, the U.S. attorney said, look, let us know if you're going to rule in favor of Brunson's. Let us know if you're going to rule so that we have to answer that summary judgment motion, and give us an extension of time so we can answer it properly. And so finally, so the point of this, why I'm talking about this, is here we are. We're fighting in state court 2 federal courts. Now, there's not an attorney on earth probably that would think that you could even do that, or that would even attempt to do that, take 2 federal courts to state court. But the U.S. attorneys are battling in state court with us. And so what happened was the judge had this incredible opportunity to do something that would have been earth-shattering and historical, but he didn't do it. And so after that was over, we got a notice from the federal court that they had decided to do what we were suing them to do, and that is file my case. So They decided to refile my case, and they decided to order the clerk of the court to issue 388 summonses. And then we went forward with process serving them all. The U.S. attorneys came on board, accepted service. So now we've got a full-blown lawsuit against the President of the United States, the Vice President, Mike Pence, and 385 current or former members of the U.S. House of Representatives and the U.S. Senate. And so that is the case right now that is in the Supreme Court. And the reason it's in the Supreme Court was, this is what happened. For a year, the judge would not make a decision on that. So a few weeks ago, he finally made a decision in favor of the U.S. attorneys. And so that gave us the green light to either take the case to the 10th Circuit or to just take it to the Supreme Court. Now, if we take it to the Supreme Court, they're just going to send it back to us because we didn't get a decision from the final court. When you do an appeal to the Supreme Court of the United States, you have to get a decision from all the lower courts. And we decided we would use their Rule 11 to see if they would classify this case as a Rule 11, which means it's of imperative public importance. That's the correct wording in Rule 11 for the Supreme Court. And if they decide it's of imperative public importance, they will decide to let us get it to them without a decision from the 10th Circuit. So in other words, they're letting us bypass the 10th Circuit Court if they characterize it as one of public imperative importance. So we're hoping that they do that. We really didn't think they would. We thought they were going to send it back and would have to fight it out in the 10th Circuit. But not too long ago, like a couple of weeks ago, we received a note. We checked the docket, and they had gone ahead and filed it with Rule 11. So if you go to supremecourt.gov, you will see the first ever petition by someone representing themselves allowed to be filed under their Rule 11. And right on the face of the petition, you'll see it'll say Rule 11. So first time ever. Now, the last time that anyone has ever been able to docket a Rule 11 like this one, a Rule 11 petition for writ of certiorari, was in the 70s during the Nixon administration, having something to do with that. And so this is really historical. If you want to get a physical copy of this, you can go to 7discoveries.com. And we printed some extra copies of this, so you can actually get, with a gift of, I think, $30, you can get a copy of this, and you see exactly what it is. It has the Supreme Court stamp on it. It has the docket number 22-1028 on it. And also, it's an opportunity to gift us, a little money, gift me the $20 or $30, whatever it is, for that copy. That shows great support. We appreciate that. And also, if you wanted to get a signed copy, there's some people that have expressed a desire to have a signed copy. And so if you have deep pockets and you can afford it, please don't do it if you can't afford it. But if you can afford it and you'd like a signed copy, there's an option for that. I think that's $1,000 gift. Then you get a signed copy. I think we throw in some books or something too with that. But so there we are right now. Today is the deadline date, midnight tonight, for the United States Solicitor General to file a response. Now, I've reached out to the Solicitor General hoping that she'll meet with me, that we can talk about, encouraging her to encourage the justices to go into conference and vote in favor of a hearing. So we're hoping that happens. But right now, we got the 22-1028 at the Supreme Court. You can go to supremecourt.gov and check it out, verify it. When you do a search at supremecourt.gov, be sure you do a docket search, because if you just type in 22-1028, you may not be able to find it unless you find the docket search where it says docket search. And then when you click on that, scroll down, because it might have popped up without you even knowing. It'll go down. There it is.
Yeah, right. I see it right at the top there, Lloyd. Docket search to the right of the search bar. And then I had pulled this up ahead of time. Cool. And so, yeah, here it is. And
okay, let's take a look. Has the Solicitor General filed a response yet? Does it show that she has filed anything yet?
I don't see it right here. The latest is May 8th.
Okay. All right. She hasn't done that. And it's not really uncommon that they don't do anything at all. In my brother's case, she filed a waiver, which she could do, but she hasn't done it in this case. So if she doesn't do that, then the court will go ahead and set a date for conference.
Yeah. What was the waiver? What was the waiver, Lloyd? I saw that when we covered the first case last year, and it's almost like she just refused to respond. What's the implication if she does a waiver?
Filing a response is not mandatory. It's an option that they have. And if they want to see this move quicker, they can file a waiver. Then as soon as a waiver is filed, let's say she had done that 3 weeks ago. If she had filed a waiver 3 weeks ago, then the court could have set a date for a conference right then. So they can't set a date for conference until she files a waiver, or until she files a response, or until the deadline passes, which is midnight tonight. And so now, after midnight tonight, the court can set a date. So we'll be watching the docket just like anyone else could tomorrow and the next day, and looking for a date to pop up for conference. And then once conference date is set, when they do that, they distribute the extra copies we sent for the justices and for their clerks, so they have a few weeks to review it before conference. The conference is where they go in by themselves with no one else, and they vote whether to move this to a hearing or not. And I'd just like to say again that because of the emergency nature that this case is, they can actually adjudicate this behind closed doors. But we hope that they make it public. We hope that they set a date for conference, and we hope that when they go into conference, they decide. All it takes is 4 out of 9 votes to move it forward to a hearing. We hope it moves to a hearing, because then it'll give us a much greater opportunity, more time to raise awareness. So regardless of what the justices do, the most important part of this whole thing is raising awareness about the Constitution, how it requires a binding oath. Article 6, to say it again, Article 6, with the very specific words that our representatives shall be bound by oath, or the word shall be bound by oath to this Constitution. They've given themselves immunity over the many years, and even some states have perjury statutes that exclude politicians regarding the oath of office, where they can actually commit perjury when they take the most important oath of office and get away with it and not be charged with perjury. So the immunity statutes and the perjury statutes have to be done away with. So a letter, you can send a letter to the Supreme Court by going to lloydbrunson.com, and it's so easy to do. Over 70,000 people have sent letters on the first one, and thousands have done it on this one. And so you can be a part of history. Go to lloydbrunson.com, and you can digitally write your own letter that goes with a form letter that's already been written to the justices, and then click a button for a $2 gift as a kind of a thank you, and that helps us, pay for postage and fulfillment. What happens then is, as soon as you click on the link, click on the button after you've signed your name with your mouse or your finger on a smartphone, and that's a great video to watch too, explaining the letter at the top of the page there. But it goes to a fulfillment house, and they print it, they fold it, they put it in an envelope, they put postage on it, and they individually mail it to the Supreme Court. Now, the Supreme Court is required to file every single letter. Now, think about it. The Supreme Court works for us, we the people. And how could they make a tremendously important decision that will affect everyone in this country? How difficult would that to be, or easier would it to be if they have a lot of support? If they don't get a lot of public support, it's going to be a little more difficult for them to make the right decision. So we're pushing and hoping for many, many letters to go to the Supreme Court, and we're hoping that President Trump and Tucker Carlson and others will encourage others to do a letter. And it's like voting for the Constitution. A letter to the Supreme Court supporting this petition is like sending your vote to them to support a binding oath that they have not respected as binding, and also upholding the Constitution of the United States, which ensures a secure Republican form of government that's required in the Constitution, a constitutional republic. And so anyone out there that wants an honest representative, I think could see a way to support this with a letter, because that's really what it's about. It's a nonpartisan, non-political movement to just get honesty, just to get our representatives to be much more honest than they've been with a binding oath. So there's the opportunity and an invitation, and we thank you guys, for those of you who have done this. We appreciate it. The support is tremendous. We appreciate it, and we encourage others and invite others to do the same, and to invite your friends. Now, you don't have to be a certain age. You don't have to be a citizen of the United States. You don't have to be living in this country. Anyone in the world can go to lloydbrunson.com and participate in this letter writing campaign to the court, which becomes a permanent part of history, with the first Rule 11 petition ever allowed to be filed in the Supreme Court of the United States by a pro se litigant, which means someone representing themselves. And as far as I understand, I've been told it's the first one ever allowed to be docketed since the 70s. And the one that was docketed in the 70s was actually filed by the U.S. government. So this is an incredible, unusual situation here. And again, you can go to 7discoveries.com to get a physical copy if you'd like, and get you can also get a physical copy of the pocket size book. I call it the Pocket Constitution, with much more. And that highlights these incredible clauses, including clauses that specifically condemn socialism. If you were to ask any representative right now to show you a clause in the Constitution that prohibits socialism, they wouldn't be able to do it unless they had this book that's available at 7discoveries.com. And if there are groups out there that want multiple copies, there's a phone number, I believe, on the website there, and there's options there where you can get, like, I think 20 copies for half the price, something like that. But it's really a gift because we want to make these available to anyone that wants or needs them. So we appreciate your gifts that you send in with this, and appreciate the support. And so that's kind of.
Yeah, that's great, Lloyd. Thank you. And it's 7 Discoveries. That's the number 7 and then discoveries.com. We've got it up on the screen right now. I'll put all these links down below this video too, so you can find them. And I'll also put, I've just been such a big fan of what you're doing, Lloyd. We've covered you a lot over the past 6 to 9 months. And you've got a lot of great videos where you go into detail on this pocket Constitution and all of the incredible, powerful provisions that you found in the Constitution that nobody knows about, nobody talks about. And I'll put some of those videos down below too, because we've covered those before, and it's really amazing what you found in this document, Lloyd, that no one is reading, but it's our foundational document in this country. So really wonderful stuff there. And go ahead and scroll below wherever you're watching this. We'll be on YouTube, we'll be on Rumble, we'll be on Twitter, but scroll down below and we'll have all those additional links and videos for you, because I really want you to see those. So you can go to 7discoveries.com and then go to LloydBrunson.com. That's LoyBrunson.com. That's where the letter writing campaign is. Lloyd, I know you've got a lot of those already. Do you have any idea how many letters have gone out already?
Let's see, about 70,000 for the first petition, and we've got about 4,000 letters so far with this one. So there's a window here. We're trying to work as fast as we can to get as many letters as we can. So thank you guys that have sent letters, and thank you in advance for you that are going to go and get your kids, your family, friends to write a letter, be a part of history. So thank you for that.
Exactly. Be a part of history. Your letter will be filed on officially in the case, and it'll live on. So there's always a lot we can do with our vote, and this is something else you can do. And we put all of us together, and it's an incredible thing. Lloyd, if you have time, I just want to ask you a couple other questions. It's such a privilege to chat with you.
Thank you. Sure.
So we're on the second case now. The first one, they declined to hear. What do you say to the people who believe the Supreme Court is compromised and either bought off or being blackmailed? Who knows what the case is with the individual justices? Maybe you got a couple good ones on there, but the other ones, are they compromised because some of the decisions they're making just don't make sense? What optimism do you have for the second case going through when they didn't seize the opportunity on the first one?
Well, it's like anything else. It's a struggle. When you're in a war, you may lose a battle or two, but if you keep hitting and pushing, people change their minds. Justices can change their minds. There can be timing and things happening where it's like it wasn't ready at that time, but it's ready now. And some people get bogged down in what the justices could do or are going to do or not do. And I would encourage them to see what's happening with people. I mean, 70,000 people are united, over like 75,000 people are united now agreeing that the oath of office needs to be binding. And how many of us really even knew that clause was in the Constitution? So what's happening is we're seeing an awakening with people, seeing the power in the Constitution. There's a great one in the Bible that says, if you know the truth shall make you free. If you know, and I say, if you know the truths in the Constitution, God can get behind those power clauses and the oath of office. And experiment. Ask your next representative that you're able to talk to, just kindly, not in an accusatory way, but just say, is there a penalty for breaking the oath of office? Because Article 6 requires the oath be binding. How is it binding, really? How is it binding? And watch them scratch their head and start thinking about it. And that's what you want them to do. You don't want to put them on the spot or do a gotcha question, but get them thinking and have a discussion about it, and they might become an ally. And I've done that. And I've experienced that where it's like, gosh, yeah, there should be more teeth. There should be something happening. I was doing that with a member of the U.S. Senate before he became a member of the U.S. Senate. He was really kind about it and honest about it, and could start to see that there was a problem there. So it's not about the justices as much as it is people becoming aware and awakened to the obligations our representatives have to the Constitution, and showing them that we know now. We maybe didn't in the past, but now we know that there's a contract and that they're bound by that contract, and we know that they're bound by that contract, and we're reminding them of that. So regardless of what the justices do, this is a really cool opportunity. But then again, the justices can do the right thing. And think about Moses. Can you imagine the story of Moses being alive at that time? And here's this man that's going to perform miracles, and he performs this incredible miracle to free everyone, and it's a plague. And what happens? It fails. Can you imagine the pushback he must have received from some people, but not the true, solid faithful people, they stuck with him. But some of the naysayers or the negative people, oh, why would a second one work? And then it's like, okay, let's try again. The second one, it doesn't work. The third one, it doesn't work. And so can you imagine the process of people losing faith, gaining faith, losing faith, trying to figure out, finally the ones that are really solid are just staying in there through every single battle because they know it's battle and they know they haven't lost yet. The war isn't over yet. The war is not over with this. And it may be just beginning, or we may be on the verge of some really incredible stuff. People are telling me that they think they're really getting a good feeling about this going to a hearing. People that didn't think the first one was going to go to a hearing. But regardless of whether it goes to a hearing or not, something really great has happened. But if it goes to a hearing, so when it's decided in conference and goes to a hearing, let's just keep battling. And that's what I say. Let's just keep battling. Let's understand the binding oath in the Constitution. People can go to sevendiscoveries.com and get the highlighted clauses, the power clauses that have been overlooked. And let's become constitutionally strong so we can keep fighting this fight to restore a constitutional republic. So the battle is great. Let's not get discouraged. Let's not be naysaying. And let's stay positive, and let's win every battle and win the war. And if we don't win some of the battles, let's win the war. And we can't win the war unless we stay fighting.
That's so good. Our guest today is Loy Brunson, having just a tremendous chat with him as expected. Loy, I love that. It's so inspirational. Is it fair to say, so you've styled this case as a Rule 11 case. The very fact that it's been docketed, is that a sign that we're on the right path here?
That is a tremendous breakthrough. It's never been done before by a pro se litigant, and never since the 70s. And so if you look, and if you go to sevendiscoveries.com, I think it's also at loybrunson.com, we have an excerpt from Rule 11, and it uses the words, they will not docket this. They will send it back to you. They will send it back to you unless they agree that it's of imperative public importance. And I think that the Rule 11, I can't remember if it's at loybrunson.com. It might be at the top of loybrunson.com. I think it's where it is. But it should be at Seven Discoveries. Let's see. Yeah, down below. Is there something there about Rule 11? Yeah, I think there is. And there's the actual wording in there. It gets a little confusing. And see, my case is pending in a circuit court.
Right,
and so
right here. Can you see this one?
There you go, to the left of the screen. So my case is pending in a circuit court. So the Supreme Court could have easily just denied. You just sent it back to us, said, nope, we're not going to accept it under Rule 11. And that's what they did with my brother's case. They wouldn't accept it as Rule 11, even though they told us they would, because the 10th Circuit Court of Appeals made a decision. So technically, we couldn't file that under Rule 11 because we didn't need to bypass the circuit court. But this one, it's docketed. It has Rule 11 stamped right on it. As you can see, the other one did not. This one is right on. So we have made some progress with the court. I mean, think about it. These two times may be the first that they've ever seen a petition sent to them requesting they be docketed under Rule 11. But it's absolutely the first time, I believe, that they've ever participated in a docketed Rule 11, as long as they've been with the court. I don't think any of the justices have ever, or anyone in the court has ever been a part of the court when a Rule 11 was docketed. So this is historical. It is unique. And it's a powerful message, I think. And so there are people, I believe, in the Supreme Court and in the clerk's office that support the Constitution of the United States. I think otherwise they would have just sent it back, and they would have, said, no, we're not going to do anything. Let the 10th Circuit Court of Appeals deal with it. But for them to allow it to be docketed under Rule 11, I think was very significant.
Oh, excellent. So, Loy, what happens next? You have 380 some people named here. That includes Biden. That includes Harris. If you're successful and these people are removed for violating their oath of office, what happens? Does it go to the speaker? Or does it go? Do we go back to 2020? What happens?
I don't know. I don't know exactly. I can't really answer that question. I could speculate, but that could be up to the justices. Now, some people say, "Oh, the court doesn't have the power to do that." Well, think about this. They've had the power to destroy babies by allowing them to be classified as non-human. That's pretty powerful in an evil way. And if the president of the United States in a state court was convicted of a capital punishment, and they appealed it to the U.S. Supreme Court, let's say he was convicted and they appealed it to the Supreme Court, the Supreme Court would have the final say on capital punishment, which is quite a dramatic way of removing someone from office. And it actually, they could cancel the credentials, they could do a lot of things, but think about it. If they canceled the credentials of the 388 defendants where they're no longer qualified or have the credentials to serve in a federal capacity, they would simply order the U.S., they could, in my mind, simply order the U.S. Marshal Service to deliver the list of those cancellations. The sergeant at arms could then cancel the credentials. The states could be notified, and the states could replace the vacancies quite quickly. And then there could be special operation teams from the U.S. government go to the Federal Communications Commission directors, and they to replace them temporarily, and also to police that. The Federal Communication directors take constitutional oaths, and they are appointed by the President of the United States. And then we could have special government teams go in to the major broadcasting stations, taking their place temporarily till everything is figured out and smoothed over. And so you could be watching, let's say you're watching CNN, and all of a sudden the commercial goes a little bit long, and then it comes back on, and you see new faces with government people, but they're dressed, in suits and business attire, and they're explaining to the public that there's something going on, that it's a smooth transition, that there's certain seats that are being vacated and replaced by the states. And then look at the opportunity for election campaigns for new candidates. You would have hundreds of millions of dollars supporting this opening up of an opportunity to replace 350 some odd vacancies in the U.S. House and Senate. So you could actually have a tremendous amount of support from the candidates, from the people that want to see the seats replaced. And so some people think, oh, it'd just be an empty, that we wouldn't have a government anymore. No, there would just be a system where we, the people and the states, replace the vacancies that were created by removing those that failed their duty, failed their constitutional responsibility to investigate when there's a warranted investigation option put on the table. And so can you imagine being on a ship and your security team comes to you and says, yeah, there's a couple of pieces of ice sticking up, but they're not very big, so it wouldn't affect the outcome of our continuing to go to the destination. And isn't that kind of what happened? Oh yeah, sure, there was fraud. There's always fraud, but not enough to change the, to affect the outcome. And it's like, well, wait a second. Don't you think we should investigate so we can nip it in the bud in case they try it next time and they are successful? It's like, hello. If you go to the police with even by yourself, let alone 100 witnesses, boy, they're going to hop to it. They're going to check it out, and they're going to find any evidence of a lead to a serious potential that could happen down the road. And that's what the Congress should have done. They should have allowed for a 10-day investigation to make sure that our elections are even more secure. And they should have prosecuted with the investigation any acts of fraud or any tampering with the election or any infiltration from foreign or domestic enemies of the Constitution. So for 385 members of Congress to say, it's not enough to worry about, that's pretty darn serious when you're talking about such an important and sacred and vital process, the election process. Think about it. An act of war simply the victor puts their leader in position, right? Well, what does an infiltrated, a fraudulent election does? It does the same thing. It puts in the victor puts in their leader. And so it was super important. And for them to not investigate this and be in favor of the investigation, they participated in a massive security breach on a major level. And so those weak members need to be removed and barred from being in a position where they can participate in a security breach ever again, and then replaced with great, wonderful people that are willing to take a binding oath to the Constitution and make sure that we don't have another security breach. So that's basically it, and why these complaints have been filed.
Wow, that is really fantastic. And it's obvious why you've been so successful, Lloyd, because this is powerful stuff that you're doing. So I love that. I know your time is short, and we really appreciate you coming on here with us. Two more questions before we wrap up, if we can.
Yeah, sure,
I know it's kind of fun. We're recording this today on a deadline day. We talked about it for the solicitor to respond. That hasn't happened yet. It will happen by the end of the day, or it won't. But other than that, what type of timeline are we looking at here in terms of the court actually doing something? Is there a deadline for them? Could it go on forever? What are we looking at?
they could, they could actually behind closed doors do something expeditiously. I mean, once tonight, at midnight rolls around or she files something, they technically can go in and they could get together and make decisions. So, but the way it usually works is they will then set a date for a conference, and a conference usually is like 3 or 4 weeks out so that the justices have time to review the documents, to review the complaint, to review the petition that's connected to the complaint. And so now that they're going to recess at the end of June, there is a possibility. And I think it's divine intervention. Whatever happens, we're doing the best we can, and people are praying, they're supporting. And I think the right thing is going to happen. And so it's very possible that they could actually not that they could set a conference date, but it could be that they could set a date for conference to be in October, since they have a recess at the end of this month until October. So it's possible. Otherwise, there's not a lot of time for them to review the petition. So it is possible, but I don't think likely that we'll see a conference date before the end of June. But if we do, then it happens that quickly. But if not, then the conference would happen in October. And if it happens in October, in a way, I'd be kind of excited, because then it gives us more time to raise public awareness. And that is so important. Of course, the security of this country is very important too. So we're just hoping that, I'm sure that the right thing will happen. And if it's set for October, we're just going to push and push and push to help people become aware of this, and ask President Trump to participate, to encourage people to write letters in support of this case, which is supporting the Constitution, and others to do the same. So my vision is 100 million letters. We have 100 million people saying, hey, we agree that the oath needs to be binding. 100 million people saying, we support the Constitution in Article 6, which states they shall be bound by oath to this Constitution. We support that. And you think about it, it doesn't matter what party you belong to, because the Republicans and Democrats are listed as defendants. So it's about an honest representation. So I would hope that Democrats and all people that vote and that don't vote would get involved and say, yeah, okay, this is a good place to start. Let's start with just making sure that Article 6 is honored, that the oath of office is binding. Let's just start there. And that's what the letter campaign is about. So I hope that people continue to share that message, LloydBrunson.com, and get more letters going in, and flood the court with positive letters that we want the oath to be binding as required in the Constitution.
Fantastic. The two websites are LloydBrunson.com and 7discoveries.com. That's the number 7 and then discoveries.com. We'll put all those links down below. Last question, Loy, those are your websites. Are you on any social medias? Which ones are really you? Which ones are not? Where do people find you?
Yeah, I should have that written down, because I have some incredible volunteers. I am on Truth Social. I am on Twitter. There are 2 Lloyd Brunson accounts on Twitter. Both of them are mine. But if anyone starts asking for money or asking for, stuff, just be very leery of that, But and Truth Social account, I'll have to find out exactly, but I do have a Truth Social account as well. I was on Facebook, but I got blocked. I think I still have a Facebook account there that I'm not really using. But it's most, yeah.
Me too, Loy. I was banned from there as well. Yeah, so it's
everyone gets banned. It seems like it's like, is anyone not banned?
It's a badge of honor, and I don't think anyone really uses it anymore anyway. So, Loy, I'll get with you after the show. We'll make sure we get the right link to your Truth Social and your Twitter accounts, so we can get those below so people can follow the real you. And we'll keep following the case. Thank you so much for coming on. We'd love to have you back on when there's another update. It sounds like there's going to be a lot of things happening.
Yes.
Well, we are fully behind your letter writing campaign. The goal is 100 million letters. By all accounts, Trump had very close to that in votes, if not more, if the truth were to be known. And so maybe we can hit that goal. There's no reason we shouldn't. So we'll get the word out, and we thank you for all you are doing. Please keep up the good work.
Thank you. Thank you for what you're doing. It's an honor to be here. Let's keep in touch.
Thank you, Loy. We'll see you next time.